All right, good morning and welcome to the 294th District Court. My name is Chris Martin. I'm going to call this morning's criminal docket. When you hear your name, please say present or here. Brad Brewer, Nelson Busby, Bryce Carroll. Mr. Carroll is appearing via Zoom today with the court's approval, and he is in the waiting room. Joseph Couch, Michael Gibbs. Mr. Schmidt is here, Brian Schmidt, and he's indicated his client's running late. We'll recall that case. Roberto Guerrera, Kirkland Huggins, Terry Johnson, Davion Pruitt, Jeremy Treadway, Aaron Vasquez, Kiana Walker. Ms. Walker is appearing via Zoom. The court's permission, and she is present in the Zoom room. Matthew Williams. Mr. Williams is appearing via Zoom. However, I do not see Mr. Williams in the waiting room. That's for arraignment. We'll recall that. Daniel Areola. And Mr. Campos, counsel for Mr. Areola, is appearing via Zoom today. Jimmy Grant. Alfonso Brown. Thank you, Mr. McBride. Manuel Guerin. Did I say that right?
Yes, sir.
All right. Thank you, sir. Miguel Ruiz. Thank you, Mr. Pointer. Ariella Gilchrist. Zibisek Goot.
Here.
Amy Holden. Milan Labakova. Jeffrey Lumen. Richard Penny. Amanda Quick. Ms. Quick is appearing via Zoom today, and she is present on Zoom. Jalen Young. Mr. Young, we have a note that he is in custody in Caddo Parish, Louisiana. We'll recall that case. Kendrick Campbell. Kilby Nip. Lara Peterson. David Webster. Cheyenne Williams. All right, is there anyone in the courtroom your name's not been called and you expect to be on the docket today? All right, I don't see anyone. Do we have any counsel that's ready? Mr. Pointer, are you ready? Go ahead and call your client up. This is cause number CR 26-00076, State of Texas versus Miguel Angel Ruiz, and we're set for arraignment today. Mr. Pointer, are you ready?
Yes.
All right, his name is spelled correctly in the indictment, and he understands what he's charged with. All right, court finding that Mr. Ruiz, having waived the formal requirements of arraignment, the court enters his plea of not guilty into the record, and the court sets this matter for pretrial. Mr. Pointer, let's see, are you available on September 15th?
Yes, I am. Yes.
No problems on that date? Okay, all right, court set September 15th. Court sets Mr. Ruiz in for pretrial September 15th. Just ask that you get with the state and get your discovery worked out so that you'll have an opportunity to file any pretrial motions before a week before the 15th. Mr. Ruiz, have you met with the court's pretrial release officer, Mr. West? You have not? All right. Well, somebody go over there. So have a seat in the hallway, and the court's pretrial release officer would be with you in just a moment. Karen, will you make sure that he's on that? All right, we have any other counsel that's ready? Mr. Casillas? All right, you ready on Mr. Grant? Is that right? All right, this is cause number CR 26-00052, State of Texas versus Jimmy Lee Grant. Mr. Grant is set for pretrial today. Any announcements, Mr. Casillas?
We will vote not guilty and ask to move from docket call when you have discovery with receiving on today.
All right, there being no discovery issues and no request for contested pretrial motions, court will set Mr. Grant then for docket call so he can announce whether he wants a trial or a plea agreement. Absent a dismissal or some other dispositive motion, court sets Mr. Grant. Are you available on September 15th?
We'll make it happen.
All right, court will set Mr. Grant then for docket call September 15th at 9 a.m. Yes, sir. Thank you, Mr. Casillas. Mr. McBride, who would you like first? All right, this is cause number CR 26-00089, State versus Manuel Jesus Guerin, and we are set for arraignment. Go ahead, Mr. McBride.
We would form a reading of the name still correctly. We understand the charges against the defendant integrally not guilty today. Do not have any discovery requests as to this case set for a trial.
All right, court finds that Mr. Guerin, having waived his waiving the formal requirements of arraignment, enters his plea of not guilty into the record, and the court sets the case for pretrial hearing. You available on September 15th?
Yes, sir.
All right, court sets Mr. Guerin then for pretrial rather, September 15th, 9 a.m. And Mr. Guerin, have you met with the court's pretrial release officer, Mr. West? Okay, have a seat in the hallway, and then once Mr. West is done with you, then you're free to go. Karen. Go ahead and check on Mr. Brown also. We'll check on all the ones that are for arraignment today. Alfonso Brown, CR 26-25. Mr. Brown set for arraignment.
Yes, sir. Brown, we understand the charges against them, waive the formal reading of the indictment. The name is spelled correctly on the indictment. Plea is not guilty to the record and would no any discovery issues at this point. And ask that we set for pretrial also on the September.
All right, court finds Mr. Brown, having waived the formal requirements of arraignment, enters his plea of not guilty into the record, and sets the matter for pretrial hearing September 15th at 9 a.m. Mr. Brown, have you met with the court's pretrial release officer yet? You have met with Mr. West? Okay, then once you sign your notice, you're free to go.
Thank you.
Yes, is that all you have, Mr. McBride? Thanks, sir. Have a good day. This is cause number CR 24-8, State of Texas versus Jeremy Lynn Treadway on the state's motion to revoke. Can you tell me your name, sir?
Yes.
Thank you, Mr. Craig. All right, and you were just recently hired on this case, is that correct?
That is correct.
All right, this being a motion to revoke, Mr. Craig, what I usually do is I can set it for an announcement and a contested hearing on a separate date. It looks like my contested date would be October 29th. I would set it for a contested date, hearing on there. If you want me to set it prior to that date for a possible resolution, I can do so. Otherwise, we can just set it on the 29th of October.
Have another, so that Your Honor, there's a legal issue that we, in the state of Texas, talked about that relates to the motions that were both filed prior to it being completed,
Okay.
which may preclude their.
Okay. Let's do that, say 2 weeks before the 29th. Are you available on the 13th or the 15th of October?
I will be out at Travelers College from October 3rd, October 26th.
October 3rd to the 26th, the whole month?
Yeah.
All right. So let's set it then. What about September 29th?
I would be in a continuous sexual abuse of a child case in Collin County in the First District Court, on the 28th of that.
What about October 27th? It's the day after you get back from your,
That works for me.
that works? Okay. All right, court will set Mr. Treadway then for an announcement on the motion to revoke on October 27th. And if there's no resolution on that day, then we'll set it for contested hearing on the 29th. And once he signs his notice, he's free to go.
Thank you.
You're welcome, sir. Nice to meet you.
Nice meeting you.
Okay, do I need it? Do I need to do it? Your guy here yet?
He's here, Dennis.
Mr. Ariola, come on up. All right, we're just gonna wait for Mr. Campos to turn on his camera and his video and his audio, and then we'll get started. Mr. Campos, if you can see and hear me, or if you can hear me, this is Judge Martin. If you'll turn on your camera, please. All right, Mr. Campos is not turning on his, hang on, here we go. There he is.
Hello, Judge.
All right, good morning, Mr. Campos. Can you hear me okay?
Yes, sir. Good morning.
All right, good morning. This is Judge Martin in the 294th District Court. I've called your client's case, and let's see here. This is cause number CR 26-77, State versus Daniel Alexis Areola, and we are set for arraignment today. Go ahead, Mr. Campos.
Mr. Ariola pleads not guilty, Your Honor.
Does he
And
understand? Go ahead.
He understands the charges, and he waives the formal reading of the charges.
Okay. All right. The court finds that Mr. Areola, having waived the formal requirements of arraignment, enters his plea of not guilty into the record. And the court will set this matter for a pretrial hearing. Mr. Campos, if you have your calendar with you, are you available on September 15th?
Yes, Your Honor, I am.
All right, court sets Mr. Areola then for a pretrial hearing September 15th. If you don't have discovery, then you need to contact the Van Zandt County Criminal District Attorney's Office and make arrangements to do so that you will have the discovery so that you can file any pretrial motions you deem necessary a week prior to that date. If on the 15th, if there are no contested pretrial issues or contested motions that need to be set and heard, then we'll move you over for an additional hearing of docket call for your client to make a decision on whether the case will be resolved by plea agreement, dismissal, or trial.
Thank you, Your Honor.
You're welcome. All right. And Mr. Campos, before I let you go, do you also represent Nelson Busby?
Yes, Your Honor.
Okay. All right, thank you, Mr. Ariola. Once you sign your notice, Mr. Ariola, have you met with the court's pretrial release officer, Mr. West? Okay, then have a seat in the hallway and he'll be out there to talk with you about your the conditions of pretrial release that are attached to your bond. He'll give you a copy of those, talk to you about those, and then once he releases you, you're free to go. All right, thank you. Mr. Busby? This is cause number CR 26-71, State of Texas versus Nelson Bryant Busby, set for arraignment. Mr. Campos, I don't have a letter of rep from you yet, but I'm sure you intend on filing one of those with the court.
Yes, I'll do that today, Judge.
Very well. All right, go ahead, Mr. Campos.
Your Honor, at this time, Mr. Busby acknowledges the charges. He enters a plea of not guilty and waives arraignment and reading of the charges.
All right, then court finding he has waived the formal requirements of arraignment. The court enters his plea of not guilty into the record. The court sets Mr. Busby then for a pretrial hearing on September 15th at 9 a.m. I'm going to have your client sign a notice of appearance today, and we'll put that date on there for him, and we'll give him a copy of that today. And then, Mr. Busby, have you met with the court's pretrial release officer yet? All right, you'll need to do so before you leave. So have a seat in the hallway. And once Mr. West discusses pretrial release conditions with you, then you'll be free to go. All right. Mr. Campos, is that all you have today?
Yes, Your Honor, may I be excused?
Yes, sir. Thank you.
Thank you.
Mr. Schmidt, you ready?
And you're.
Michael Allen Gibbs, CR 26-50.
Your Honor, we just filed a letter of representation this morning.
All right, you may proceed.
Thank you, Judge. I have reviewed a copy of the indictment. Mr. Gibbons' name is spelled correctly. He understands the nature of the charge. We waive the formal reading of the indictment and a plea of not guilty.
All right, the court does enter Mr. Gibbs' plea of not guilty into the record, finds that he's waived the formal requirements of arraignment. And as for pretrial, Mr. Schmidt, are you available September 15th?
I am, Your Honor.
All right, court sets Mr. Gibbs in September 15th at 9 a.m. And Mr. Gibbs, have you met with the court's pretrial release officer?
Yes.
You have? All right, then once you sign your notice, you're free to go.
Yeah. That's all I have for you.
Yes, thank you, Mr. Schmidt. Good to see you. It'll be after I call the docket. All right, Mr. Schmidt, who are you ready on?
Approved.
Davion Daryl Pruitt, CR 26-74. Mr. Pruitt is set for arraignment today.
And spelled correctly. What are you reading in a plea?
All right, court does enter Mr. Pruitt's plea of not guilty into the record, finds that he's waived the formal requirements of arraignment. Court sets pretrial September 15th at 9 a.m. And Mr. Pruitt, have you met with the court's pretrial release officer, Mr. West? All right, you'll need to have a seat in the hallway and let him discuss those with you. And once he's done and he releases you, you're free to go. Who's next? Zibiset Goot. Good morning, good morning. Give me just 1 second here. All right, this is cause number CR 26-12, and Mr. Goot is set for docket call. All right. And State, have you made an offer to Mr. Goot?
Yeah.
Do you know what was the offer extended by the state? 4 years deferred? And that's been rejected by your client, and he understands that court may not allow him to plead after today?
Yes.
All right. Court sets Mr. Goot then for jury selection beginning August 31st. Mr. Goot, on that date, you will not appear in the courtroom. You'll appear downstairs. My staff will meet with you and they will give you instructions about your next appearance date if you're not reached for trial.
And Your Honor, here is a court listed. Disability and travel expenses are beyond this means. We ask that he's allowed to appear to those recess fees or the top 10 very least.
State, you have a position?
Your Honor.
Only problem I have with that, Mr. Schmidt, is I can't drug test Mr. Goot in Florida, and he's charged with drugs.
That's great, Judge. And this, DD5 DA's office with this scripts, prescription medication that Mr. Gary is on. You can have he would be following for quite a year of the tests, but prescription medications.
So what I'll do, since it's since it's August 11th, I will grant the Zoom request for August 31st. But the next time that he is set, it'll be in person. We'll do like in every other one, as long as there's no issues on pretrial release. Amy Joe Holden, CR 26-29. I showed Mrs. Holden's a plea today. Is that correct?
It's clean. Recall, if you don't.
Is it a plea?
We would like to, and we would accept this, so if we have to do work, get it done.
Has the paperwork been?
It's signed in your honors. It's in the
All right,
system.
let me look real quick. Well, hang on just a second, because if it's here, we'll do it.
And then maybe the judge, I haven't checked, charged them that back city, but
I don't see it in my email.
we haven't signed.
Oh, you have not? Okay. Milan Labakova, CR 26-54. Mr. Labakova is set for pretrial.
This, future on,
All right, there being no contested pretrials, court sets Mr. Labakova for docket call September 15th at 9 a.m. Jeffrey Don Lumen, CR 26-23. Mr. Lumen is set for docket call. Court will note for the record that Mr. Lumen has been UA today and is negative. But I do show that there's a concern about delinquency on pretrial release fees of $120. Announcements.
Yes, sir.
All right, what offer, if any, was extended and rejected?
10 years. Probably.
10 pro 10. All right, and Mr. Lumen understands that court may not allow him to enter a plea after today.
Yes.
And that whether the offer gets better or worse, that if he asks for a trial, he's gonna get a trial.
Where is it?
All right. All right, court places Mr. Lumen on the jury selection docket beginning August 31st. Mr. Lumen, you'll meet downstairs with my staff and they'll give you directions about your next setting. And what about your delinquency on pretrial release fees? Have you paid those?
I caught 100, but then.
Okay. All right, so you said you paid 100 on Friday the 7th? Thank you. All right, just see that you keep it from becoming delinquent. All right, once you sign your notice, free to go.
Richard Penny.
Richard Edward Penny, CR 2685, CR 2690. Mr. Penny is set for arraignment on assault causes bodily injury, Class A misdemeanor, and possession of controlled substance, second-degree felony.
That has been waive reading and plead not guilty to both charges as to the pre-trial cell.
All right, court enters Mr. Penny's plea of not guilty to each charge. Court sets Mr. Penny then for pretrial September 15th in each case. And Mr. Penny, have you met with the court's pretrial release officer, Mr. West? Okay, then have a seat in the hallway, and once he meets with you, he'll go over the paperwork, and then you'll be free to go. All right?
But, we got Gilchrist, home and we try to get this figured done. Jalen, got him with his staff. Custody of the bad there.
What about, I've got Amanda Quick appearing via Zoom, and she's here. Do you want to do that one? And Mr. Schmidt, if you would, just maybe for this one, come up to the square so she can see you. All right, good morning, Miss Quick. Can you hear me okay?
Yes, sir.
Excellent. This is Judge Martin. We're in court, and I'm calling your case at this time at CR 26-75, State versus Amanda Jo Quick, and we're set for arraignment today. Court is allowing you to appear via Zoom, and your court-appointed attorney, Mr. Richard Schmidt, is here before you. Can you see him?
Yes, sir.
All right. Mr. Schmidt, any announcements on Miss Quick for arraignment?
Yes, sir. I have spoken to Ms. Quick's family members. Her name is spelled correctly. We understand the nature of the charges. We will enter a plea of not guilty, waive reading, ask for a pretrial sentence.
All right, court sets, or the court does enter Ms. Quick's plea of not guilty into the record, and the court sets her for pretrial hearing on September 15th at 9 a.m. Ms. Quick, do you anticipate still being in the Homeward Bound program on September 15th?
No, sir.
All right, you expect to be out and back in Van Zandt County?
Yes, sir.
Okay, so you'll appear in person on September 15th at 9 a.m. in the 294th District Court. All right?
Yes, sir.
All right, you are free to go.
Thank you.
You're welcome. Mr. Have you seen Nolan? Have you seen Mr. White? Have you seen Mr. White? Is he? Yeah, he's got a lot. I didn't know, maybe he's out in the hallway talking. Just let him know if he's ready, I'm ready. Mr. Craig, it's gonna be a little bit.
Yeah.
Mr. Brewer? All right, this is Sanctions Court hearing, cause number CR 23-6. All right, Mr. Brewer, I've got that you complied with everything we talked about in our last setting. You paid your 245 to probation, your 100 to collections, your 20 hours of community service. That's good work. All right, I'm going to reset you for September 15th. $245 to your probation fees and work 20 hours of community service, okay? Oh, you did today? The fines? Yeah, you.
And restitution.
What's the 245 for? Delinquent reporting fees? Well, I do show that you worked 20. Is that what you're saying? Over the total of 210? Okay, well, if you've done all the time, then you don't need to do any more, but I want you to confirm that with your probation officer.
Yes,
All right, I'll tell you what, come back here and have a seat in the jury room and talk with him here. And he's good on, he says he's on his, he's done his community service also. So just release him. All right, Mr. Brewer. Ms. Burns is confirmed. So what I'm gonna do today is I'm gonna go ahead and release you from sanctions court. Okay? So that, doesn't mean that you're off, community supervision. It just means you're not having to come back to sanctions court. All right, so report, do what you're supposed to, and be successful. All right? All right, good work. We'll see you later. Or no, actually, we won't see you later. Okay. All right, good morning, Mr. Carroll. Can you hear me okay?
Good morning, yes, sir.
All right, I'm gonna call your case. This is sanctions court hearing CR 21-208, State versus Bryce Carroll. Mr. Carroll, I've authorized you to appear via Zoom today. Probation has indicated that you paid your $60 to the probation for their fees. What about your 300 to court collections? Did you pay that recently?
I'll make a payment this Friday when I get paid.
So
I know
you're
I have to
paying,
catch up for this month and I believe last month.
yeah, so if you didn't pay for this month, then you're gonna have to pay this month and then you'll have to pay again before our next hearing. So
Okay,
I'll
I can
let
do
you,
that.
I'll let you pay this next Friday. Just know that I'm gonna have you come back on September 15th and I'll let you appear via Zoom, but you need to pay your 300 that was due for today. You need to pay that this week and you need to pay 300 again before you come back on September 15th.
Okay, I can do that.
Okay? All right, we'll see you back on the 15th at 9 a.m. on Zoom. Okay?
All right, thank you.
You're welcome. Oh, Mr. Carroll,
Yes,
before
sir.
you go, I'm sorry. Miss Burns, indicated that, you need to report in person. They want you here in person on the 15th, okay?
Okay,
So not Zoom. So we'll see you on September 15th at, 9 a.m. All right?
all right, gotcha.
All right. Thank you, sir.
Thank you.
That was court costs. Yeah, 60 to probation, 300 to collections. Let's get Miss Walker.
Hello.
Good morning, Miss Walker. Can you hear me okay?
Good morning, Judge. Yes, I can hear you.
All right, I'm going to call your case for sanctions court. This is cause number CR 21-312, State versus Kiana Walker. Sanctions court hearing. Miss Walker, let's see. Your probation officers have reported that you paid your 200 to probation fees. You paid your 100 to collections. And they reported that you came up short on your community service. They said you worked 11 out of 20. Is that right?
Yes, sir.
Okay. Last time we talked, I think you were in the process of trying to land a new job. Is that right?
Yes, sir.
Were you successful?
Yes, sir. That was the reason why. And the community service place that I go to, the Martin Luther King Center, due to budget costs or Dallas costs or whatever, the Saturdays they're to close now or something. So they changed their schedule. So and I did land a job. So the job that I landed, I was working Monday through Friday on first shift for the first week of training. And the second week I did second shift. And then the third week, now I'm on graveyard shift. So when I went to go for those days that I normally go, they wasn't open on those days. So now I will have to go during a weekday. And I guess it kind of works out because the job that I have now, I'm not off on the weekend. So I'm off on a Thursday. So that's the day that I plan on doing it. I do only have 36 hours left.
Okay, great. All right, then let's do this. You said you're off on Thursdays, right?
Yes, sir.
Okay, so what I'm going to do is I'm going to give you a new court date of September 17th, okay? That is a Thursday, but I want you to come in person, okay? Come in person so that you can see the probation officer, so they can do their paperwork and drug test or whatever they want to do, okay? But so far it's looking really good. Looks like you're kind of course correcting. So on the 17th, then I want you to have done the same things. I want you to pay 200 towards your probation fees, 100 toward your court collection fees, and your 20-hour or however, what did you say your remainder was on your probation
It's
community
30,
service?
it's 36.
All right. Well, let's try to get 20 done.
Okay.
All right, let's try to get 20 done. That'll be our goal, okay?
Okay.
And that means you're almost there.
Almost with the plan. Hopefully everything goes correct. If I continue paying, because right now it's saying that I'm 760 behind. But if I continue paying the amount by December, I should be good. So starting in January, then I'll be back on the regular plan because my court costs, I think it's only like 375. So I only think I have like 3 months left for that. But like I said, that's if everything goes as planned with the way my life is set up. You just never know. But I'm trying to maintain this job and hopefully, that works out. It's a very strenuous job, I can say that.
What kind of work are you doing? And you don't have to say where you're working, but what kind of work are you doing?
I work at a warehouse job and then that's another thing. They have this type of thing where they call it force. So on any given day, I don't know if I would have to work over. And they have this in their system where when you sign up for the job or when you agree, it's called force. They can force you to work over 4 hours. They can force you in on your off day. They can force you if somebody else and it's a union company, so they go based on seniority. So with me being one of the last hiring classes, if somebody doesn't come in, then I can be forced over or I can be forced in. And that's what like scares me when I have other engagements that I have to do, especially like court or something like that. And those would coincide with each other and you just never know. So it's not a set thing like, okay, well, my schedule is now 9:30 to 6 a.m. and I'm getting off at 6 a.m. and hey, I have court at 9. So I'm gonna drive to court, but then they say, no, you have to stay 4 hours because somebody else didn't come in or something like that. And it's in the paperwork. So it's like I can't fight it. It's either do it or lose your job or something. But
Well, you know this, Miss Walker. We want you to be employed, right? Because that's good for you. It helps move you along in your community supervision, and it keeps you out of trouble, and it's good for you, right? So we're going to continue to work with you. I know it may be strenuous, and stressful, but you know what's more strenuous and more stressful? Not having a job and having court obligations that could land you in prison. So when you start worrying about how stressful and strenuous it is, just know it could always be worse. So be thankful for what you got and accept that it is challenging, that it is hard, but know that you are moving in the right direction and just bear down and get it done. Okay. So you're doing good. I'm giving you praise. I'm just trying
I
to build
I
you
really
up.
do appreciate it. And I'm looking forward to this 9 month. It's like it's so far away, yet it's so close. And I'm
Yeah.
just like, I'm really like overwhelmed at this point. So I want everything to be successful. I feel like I'm at the end, the finish line, and I want everything to be good. And I'm working so hard to just, maintain it. But it's like it's really hard. So I appreciate it. You giving me the praise because I feel like I'm failing all the time because I can't. It's like I can't get stuff right, and I'm just overwhelmed. So I'm
Well,
trying with what I
well,
can do.
well, you're doing good. You're doing good. Keep it up. It is 9 months will go by quick. So make that your first goal. All right. Make your first goal, keep your job, get through your community supervision, and then you can get us out of your life pretty soon. And once we're out of your life, it'll be easier for you. Okay. So, hey, when you come in on September 17th, then you can meet with your probation officer and you all can look together at exactly how much you owe, kind of when payments can go down, things of that nature, okay? And that way, when you leave on the 17th, you'll have a really good view of what to expect and kind of what you got to do, okay?
So how long do I have to do sanctions court? Is it gonna be every month until I'm caught up? So this is gonna be till December?
I tell you what, let's talk about that on the 17th when I see you in person, okay?
Okay.
All righty. All right, keep up the good work. We'll see you on the 17th at 9 a.m., okay?
All right. Thank you so much. You have a
You're
good day.
you're welcome. You too.
Bye-bye.
Mr. White, are you ready?
Yes.
Who are you ready on?
This is.
Kilby Nip CR 26-32 for pretrial.
Well, go ahead. Technically, probably. I'll say you're aware of that situation I've had.
Any objections from the state?
No, you're on.
All right, so because I'm going to set it out so far, Mr. White, I'm going to impose a final docket call because she's going to have a lot of time. You'll have a lot of time to talk about it and she can make her decision. Okay. All right, court sets final docket call. November, are you available November 10th?
Yes.
All right, court sets final docket call November 10th at 9 a.m. Free to go. Who'd you like next?
This is with.
David Claude Webster, CR 26-88. And Mr. Webster is set for arraignment.
Honor, this is Webster. Oh, correct. This time, you're free.
All right, court enters Mr. Webster's plea of not guilty into the record, sets this matter for pretrial. Are you also asking for a November date?
Yes, sir.
All right, court sets Mr. Webster for pretrial November 10th at 9 a.m. Mr. Webster, have you met with the court's pretrial release officer, Mr. West?
Yes.
Okay, all right, then if you've met with him, you're free to go.
Thank you, Your Honor.
You're welcome.
Mr. Campbell.
Kendrick Campbell, CR 26-78. Mr. Campbell is set for arraignment today.
Yes, sir. This can be set for arraignment. We see a copy of the indictment, Mr. Campbell's first name in the indictment, spelled correct.
All right, the court enters Mr. Campbell's plea of not guilty into the record. The court sets this matter for pretrial hearing November 10th at 9 a.m. Mr. Campbell, have you met with the court's pretrial release officer, Mr. West? Okay, then you'll need to have a seat in the hallway and he'll come and talk with you about your conditions of pretrial release. And then once he's done with you, you're free to go. Lara Patterson, CR 26-61. All right, Ms. Patterson is set for arraignment.
Your Honor. Name is spelled correct.
All right, court enters Ms. Pedersen's plea of not guilty into the record, sets this matter for pretrial hearing November 10th at 9 a.m. Ms. Pedersen, have you met with the court's pretrial release officer, Mr. West? You have? Okay. Once you sign your notice of appearance, you are free to go. You're welcome. Who's next?
Mr. Hughes.
Cheyenne Williams, CR 2624. All right, Ms. Williams is set for final docket call today.
Your Honor, the sever I provided the state with some information. They indicated to me that they were gonna have the alleged victim come in and talk to them. I'm not opposed. If the court wants to just put it over to the jury selection docket, doing so. And then if we need, but we would ask the court if we have additional information and the state would change their mind on how they would proceed, that we can come in, resolve.
When was the information provided?
I got it over to them yesterday. There was things I was waiting on, which she got up to me. And broken off.
That's okay. I'd rather just talk about generalities. So what's the offer that the state has made today?
Eating up.
No offer? Okay. All right, I'm just going to place her on the jury selection docket beginning August 31st. And if the parties believe that they can reach an agreement, then notify the court, and the court may or may not let her plead, since today was final docket call and there was no announcement as to a plea. Let's call Mr. Jalen Young. I think we have that one. Oh, actually, no, I'm sorry. You're right. That's Mr. Schmidt. I apologize. I apologize. Sorry. Thank you, Mr. White. Mr. Huggins. All right, this is cause number CR 2125, sanctions court hearing for Mr. Kirkland Wade Huggins. And let's see, Mr. Huggins, I show that you have complied with your probation payments, your court collection payments, your community service, and your counseling. All that looks good. Have a note here that says you're interested in transferring your probation to Aransas County for a job opportunity. Is that right?
I want to community service first time in 2 hours. I want to complete that here first, and then I would like to transfer there. My cousin lives down there, and my uncle does, and I'm going to work with my uncle's clothing business down there. With everything that's been going on in my personal life, 5 divorces, everything else. Just wanting a fresh start, and I want to get my community service done to where I only have to pay my fines up there. And I got a little, I think it's a little under $1,000 between my court costs and my probation.
All right, but you're saying that you want to complete your community service before you go?
Yes, sir.
But you're saying that you would not have all of your financials paid off or caught up. Would you have them caught up?
Yes, sir. I would have a transfer.
Okay, I'm not opposed to that, Mr. Huggins. I'm not opposed to that. So, but ball's still in your court. You get all of that done, and probation. Talk to your probation officer, and if they're supportive of it, then I'm not opposed to getting you to another spot if that's where you want to be for employment purposes.
Yes, sir.
How soon are you wanting to do all of that, or planning to do all that?
I'm trying to get everything
I don't know, I'm over here wanting to keep me in sanctions for it. So
Well, no, I'm saying, how long do you think it would take you to finish up your hours and get current on your,
I'm not trying to.
okay. Do all of that, talk to your probation officer. If they're supportive, they'll come to me, I'll be supportive. Okay? So I'm gonna have you come back on September 15th and let's do 1:30 to probation, 80 to court collections, 20 hours community service. I mean, you've almost got that done. I think 22 left, yeah. How about we just say 22 hours and get you done on that? Okay. And then continue with your counseling. Ms. Burns, Mr. Huggins is wanting to transfer probation. Would you be supportive of that if he gets everything caught up? And have a good day, sir. Here's Mr. Huggins. So,
Feel that anyway.
Aaron Vasquez. All right, Mr. Vasquez, this is a sanctions court hearing, CR 21394. All right, Mr. Vasquez, let's see here. I've got some notes. You were ordered to do 24 hours community service. It says that you did 13 and a half.
Yeah, I did it.
12 hours of for what, like payment to like a food bank or something?
Yes, sir. Man.
Manna. Okay. And did you turn that into your probation officer?
I'm about to.
Okay. Come back here and meet with Miss Burns. Will you figure that out? Right, yeah, right over here. How much community service did you do? Think you completed it? All right, come over here and meet with the probation officers and they'll meet with you. Let me know. All right, Mr. Crick. You may. All right, this is back on CR 24-00008, State versus Jeremy Lynn Treadway. Go ahead.
Yes, Your Honor. I was talking to Mr. Hall about a logistical issue. My client was, after he was gone to the jury trial, he was informed he couldn't go back home with his kids. And so I know it looks like standard terms and conditions of probation had the standard no contact with the child under the age of 18. During pretrial supervision, he was allowed to remain home with the children, and they were forensically interviewed during the course of the investigation and cleared with any sort of allegations. And so I talked to Mr. Hall about if we can just approach the bench to see if we can handle it now, or if you'd like me to set up for a hearing about him being allowed to return to his house. His kids are 8 and 11.
So you're asking to modify his conditions community supervision?
Correct. And the reason why I'm asking to approach without a hearing is because he had the history while on pretrial supervision and no violations of that. Forensic interviews cleared them. But I told Mr. Hall I would approach, and then if you asked for a hearing and all that, of course we would do that.
Yeah, court would require you to file a motion so it's of record and then have a hearing.
Yes, sir.
I'm sure the state's not in agreement. And I'm confident they're not in agreement.
I understand.
So, yeah, follow your motion and we'll set it for hearing.
Okay, will do. Thank you.
Yes, sir. Thank you, Mr. Craig. I don't believe. Yeah, I think they just brought it here. Mr. Couch. Come on up. All right, this is on record, cause number CR 21-53, State of Texas versus Joseph Couch. All right, Mr. Couch, you're here today You're requesting amendment to your conditions of community supervision. Is that correct? And it appears that you're asking the court to extend you for an additional 2 years. It looks like you are set to expire tomorrow, and you're asking the court to extend you until August 11th of 2028. Is that correct?
Yes, sir, I just take out the, if I want some fees.
Okay. And you understand that during the extension, that you would incur additional fees such as probation reporting fees? You understand that?
Daughter born in September, very many disease. And she's been one of her life, working in hospital, the coast hospital. And I've been staying there with her, and I really haven't had, I don't think any community service or get caught up. I paid as much as I could this morning, paid her $1,000 for probation. Now another $1,000 I've saved up to get paid. So I was wondering if I could get, my probation hours or my community service hours included, some of my fines reduced. So I can get caught up.
Okay.
And I have letters from her conference here that they received notice that I had for, they, wrote me letters to get to you, you're like,
Well, hold on to those. That's a little premature. So right now, we're just talking about extending your community supervision. And okay, so you're asking me to do this because this is what you want to do, not because you feel threatened or forced or pressured. All right, then the court will grant the amendment to the conditions of community supervision. Court will extend the probationary period to August 11th of 2028. And the court will amend condition M2 as well, requiring him to pay probation fees of $60 a month. All right, so now that that's handled, Mr. Couch, meet with your probation officer, talk to them about possible ways to work around the community service issues. As far as reducing your fines and fees and all of that, I'm not gonna entertain that at this time. Let's talk about things that we can adjust easily, the conditions of community supervision, things like that, so that you can focus on your daughter's health. But talk with them about that first. Let's come up with a plan, and then they will approach the court, okay? All right, come over here and see Officer Matura, and she will get you a copy of this, have you sign it, and then you're good to go. If you need that, here, we don't have to put it on the record. Do you wanna, so we don't wanna do the 20? And and what do we want? Those two things, 24 and 100? Same thing, 24. Yeah, they said 24 hours in jail for not working, but you said he's good, so 1, 2, and then, will you, Mr. Vasquez, just do that. I'm not gonna call him back in here. I'm gonna give it to Carrie and she'll have him sign it. Here's Mr. Manselko. Mr. Guerrera? All right, this is cause numbers CR 26-72 and CR 26-73. State versus Roberto Abreu Guerrera. All right, Mr. Guerrera, you are indicted and set for arraignment on 2 charges. Both are aggravated assault with a deadly weapon. Both are second-degree felonies. Each crime carries a range of punishment if you were to be convicted and sentenced to not less than 2 years or more than 20 years confinement in prison, and you could also be fined up to $10,000 in each case. I see that you have requested a court-appointed attorney. Based on the court's review of your application and the information you provided, you do not meet the requirements under the law for indigency, meaning that you have financial ability to hire an attorney. So what I'm going to do, Mr. Guerrera, do you need the assistance of an interpreter at all? Or is your English for the next one? Today, do you understand what I'm telling you so far? Okay. All right. So what I can do is I can make arrangements to have an interpreter here for you. But what I'm going to do is I'm going to reset you for September 15th and give you an additional 30 days to hire an attorney to represent you on these things. You also have the right to represent yourself, but before we talk about that, you would have to satisfy a lot of circumstances for the court before the court would feel comfortable in allowing you to represent yourself. Okay. So I'm gonna have you come back on September 15th and we're gonna bring you a form. Let's come back on September 15th. And then if you don't have the attorney hired by then, you can tell me what progress you've made, who you've talked to, how much money you've paid down, how much money you've saved. Okay. And then if you are making progress to doing that, then I will consider setting you another 30 days so that you can finalize hiring the attorney.
With my circumstances, I have to go to Mexico and back, see my voice. I work here, and on the middle of September. That case, I'm asking if it's possible at the end of September.
Okay, I'll tell you, so we'll change the date to September 29th. Is that better? Okay. All right, I'll do that for you, Mr. Guerrero. Got no problem with that. September 29th at 9 a.m. And Mr. Guerra, have you met with Mr. West, the court's pretrial release officer? Okay, then once you get your notice, then you're free to go, and we'll see you back on September 29th. You're welcome. Have a good day, sir. Good. Okay, so he's good to go. Yeah. Yeah. Yeah, that'll work. Have you done a reset for Mr. Johnson yet? Let's see her. Here, she'll fill it out. You just write in there. Yeah, we just kind of write it out there. We're supposed to. The All right, court's going to stand in recess for 15 minutes. All right, court is now back on record. Mr. Schmidt, who are you ready on?
Just should have, Holden and Gilbert.
All right, Amy Holden. All right, court calls, cause number CR 26-29, State of Texas versus Amy Jo Holden. Ms. Holden, if you will raise your hand, I'm going to place you under oath. Do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, thank you. You can lower your hand. All right, Ms. Holden, are you a United States citizen who reads, writes, and speaks English? Have you ever been diagnosed with a mental condition? In this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with him as your attorney? Do you have any questions about anything that you have read and signed today that's part of your plea agreement? Mr. Schmidt, do you believe Ms. Holden to be competent? And if so, have you explained to her her rights as they pertain to this case, including the advantages and disadvantages of a deferred adjudication plea?
Yeah.
All right, Ms. Holden, in this cause, you are charged with possession of a controlled substance in penalty group 1, greater than 1 grams, less than 4 grams. That is a third-degree felony. It does carry a range of punishment of not less than 2 years or more than 10 years in prison, and a possible fine not to exceed $10,000. I see your plea agreement is, upon you pleading guilty, the state's recommending that the court consider the evidence. The court is to defer a finding of guilt and place you on community supervision for a period of 6 years, assess a $2,000 fine, assess restitution of $180, court cost of $290, and reimbursement fees of $535. As part of the agreement, the state is dismissing some unfiled cases, which appear to be unlawful carrying of a weapon, possession of a controlled substance, and it appears also that there's an agreement for the weapon that was seized in your unlawful carrying of a weapon case that it shall be forfeited in this case. The plea agreement has a question mark in the thing. It says to what agency question mark. I'm not sure what that means, but it's in there. It's a High Point MD 45 caliber pistol. Do y'all know what that means? What agency question mark?
She had asked, he had asked me what you see, and I responded, or yes, and sheriff. So I don't, maybe she didn't catch that and then put that in there.
Yeah, well, I mean, she just wrote to what agency question mark, but so it looks like the order is going to have to be amended under the, well, let's see. Let me see if I can make this bigger. Under the special findings, let me see if she put sheriff's office in there. Okay, she did put under the special findings for the Van Zandt County Sheriff's Office to receive the weapon. Okay, that'll be fine. All right, Ms. Holden, I've read the plea agreement to you. Is that your understanding of the plea agreement and what you're asking the court to approve? All right, Ms. Holden, at this time, how do you plead to possession of a controlled substance in penalty group 1, greater than 1 grams, less than 4 grams? Are you pleading guilty to that crime because you are in fact guilty of committing that crime? And has anyone threatened you, forced you, or pressured you to plead guilty here today? All right, the court does accept the defendant's plea of guilt. Mr. Schmidt, any objection to the stipulation of evidence?
No.
All right, the evidence is admitted and the court does take judicial notice of the defendant's judicial confession. Anything further from the state?
No.
From the defense?
No.
All right, court will review the evidence at this time. All right, the court, having reviewed the evidence, finds enough evidence to convict the defendant of the offense. The court will follow the plea agreement today. The court defers the finding of guilt, places the defendant on 6 years community supervision, orders her to pay a $2,000 fine, $180 in restitution, $290 in court costs, $535 in reimbursement fees. And the court does take into consideration and dismiss under section 1245, unlawful carrying of a weapon, DA 2026-114, and also possession of a controlled substance, DA 2026-830, and the court hereby orders the forfeiture of the weapon seized from DA 2026-114, namely a High Point MD 45 caliber pistol, as laid out in the judgment of the court. Ms. Holden, you're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'm going to have you be fingerprinted with the bailiff, and then you'll report to probation. If you want to go and get your next client, Mr. Schmidt, I'm going to sign this paperwork. Patty, make sure that that plea agreement went through. I signed it and sent it. It said submit, but then I had another window open up and it repopulated the plea agreement. So I'm concerned that it might not have gone through. Ms. Gilchrist? All right, this is cause numbers 2023-77, CR 25-200, State of Texas versus Ariella Fallon Gilchrist. And Ms. Gilchrist, if you will raise your right hand, I'm going to place you under oath. Do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you can lower your hand. Your name is Ariella Fallon Gilchrist, is that correct? And Ms. Gilchrist, are you a United States citizen who reads, writes, and speaks English? Have you ever been diagnosed with a mental condition? And can you tell me what that is? Okay. Are you under treatment or on medication for that here today? Okay. Do you feel like your diagnosis for that mental health disorder is in any way affecting your ability to rationally understand what's going on in your case with your attorney and with this court? Okay. You are represented by your attorney, Mr. Schmidt. Are you pleased with him and the work that he's done? Do you have any questions about anything, including the paperwork that you've read and signed today, part of your plea agreement? Mr. Schmidt, do you believe Ms. Gilchrist is competent today? And if so, that she's entering into this agreement intentionally, knowingly, and voluntarily after understanding her legal rights?
Yes.
And you've also explained to her the advantages and disadvantages of a deferred adjudication plea? All right, Ms. Gilchrist, in cause number CR 25-200, you are charged with a second-degree felony offense of possession of a controlled substance in penalty group 1 or 1B greater than 4 grams, less than 200 grams. That does carry a range of punishment of not less than 2 or more than 20 years in prison and a possible fine not to exceed $10,000. I see your plea agreement in the case. Upon you pleading guilty, state's recommending that the court consider the evidence, that the court defer a finding of guilt, court placing you on community supervision for a period of 8 years, and ordering you to pay a fine of $2,000, restitution of $2,611.69. In addition, you would be ordered to pay court costs of $290 and reimbursement fees of $585. As part of the plea agreement, the state is agreeing to dismiss some unfiled cases of possession of controlled substance and also a tampering or fabricating physical evidence. Ms. Gilchrist, is that your understanding of the plea agreement? You're asking the court to approve this today? All right, understanding those things, Ms. Gilchrist, how do you plead to possession of a controlled substance in penalty group 1 or 1B greater than 4 grams, less than 200 grams? Are you pleading guilty to this crime because you are in fact guilty of committing the crime? And has anyone threatened you, forced you, or pressured you to plead guilty here today? All right, the court does accept the defendant's plea of guilt. Court will admit the stipulated evidence to support the plea. Anything further from the state? Anything further from the defense?
No, sir, your honors. Mr. Mayor, Kaufman, here as well. Motion to approve.
All right, Ms. Gilchrist, with regards to cause number 2023-77, you appeared before the court previously on November 20th of 2023. You pled guilty to the Class A misdemeanor offense of assault causes bodily injury. The court heard the evidence and found that there was enough evidence to convict you. However, the court followed a plea agreement on that date, and the court deferred a finding of guilt and placed you on community supervision for a period of 15 months. The court then extended your community supervision for an additional period of 1 year. And during that period of your community supervision, the state filed its motion to adjudicate and revoke your community supervision. And they have alleged 5 separate allegations of violations. And have you had enough time to review those allegations with your attorney, Mr. Schmidt? And Mr. Schmidt, does your client waive the formal reading of the state's motion?
You do.
Does she intend to plead true to all counts?
Yes.
I see, Ms. Gilchrist, that you have an agreement in this case as well. Upon you pleading true to the violations, the state is asking the court to adjudicate your guilt. That means to convict you. And they're asking that your community supervision be revoked, that your punishment be assessed at 104 days confinement in the county jail, for which you would receive credit for time served of 104 days. But you would be responsible for, in order to pay your remaining financial obligations, which is a $1,000 fine and $530 in reimbursement fees to the county. Is that your understanding of the plea agreement in that case? And Ms. Gilchrist, how do you plead to counts 1 through 5? Are those counts true or not true? And has anyone threatened you, forced you, or pressured you to plead true to any of those counts? Okay, court will accept the defendant's plea of true to counts 1 through 5. The court admits the defendant's waiver of rights and plea of true into evidence. Anything further from the state on the motion to revoke from the defense?
No.
All right, then, having considered the evidence in each case and cause number CR 25-200, court finds that there is enough evidence to substantiate the guilt of Ms. Gilchrist. The court will follow the plea agreement. The court defers a finding of guilt on the lesser included offense of possession of a controlled substance greater than 4 grams, less than 200 grams. Court places the defendant on 8 years community supervision, orders her to pay a $2,000 fine, restitution in the amount of $2,611.69. Let me correct that for the record. Restitution in the amount of $2,611.69. Court orders her to pay court cost of $290 and reimbursement fees of $585. The court does dismiss under section 1245. Unfiled cause numbers DA 2026-902, possession of controlled substance, and DA 2026-903, tampering or fabricating physical evidence. With regards to cause number 2023-77, the court finds that the defendant has violated the terms and conditions of her community supervision. The court, based on that finding, revokes her community supervision, adjudicates her guilt, and pursuant to the plea agreement, assesses her punishment at 104 days confinement in the county jail. gives her credit for 104 days of time served and orders her to pay the balance of her financial obligations. Ms. Gilchrist, you're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of their sentence. And before you go there real quick, were the conditions of community supervision in the felony case, did they take into account payment of any of her financial obligations, restitution, reimbursement of her misdemeanor case? Okay, so you're gonna be on your own to pay what your court ordered to pay on your misdemeanor case. I'm sure your attorneys talked to you about that. You're gonna be paying your felony case, restitution, fines, fees, court costs, reimbursements, and then you're gonna have a judgment on that misdemeanor case. Failure to pay those could result in you being arrested on a KPS profile. You understand that? Okay, all right, I'll have you come over here and report to probation. What are you talking about? You did not? Okay. May have to go back and do it again then. All right, I just sent you one on Miss Gilchrist. Says it's processing. Okay, that one was finished. And now I'm gonna send you the misdemeanor one. So you did not get the one on Miss Holden, correct? All right, let me sign it again. Maybe there's a delay because it says I've already signed it. So it shows to be expired in mine.
2 minutes.
All right, court calls for the record CR 25-224 State versus Jalen D. Young. Status hearing, he's still in custody in Caddo Parish. Any update from the state on Mr. Jalen Deshaun Young?
No, sir. No, I haven't been able to get any information of all that. Yes.
From the defense? All right, court will set Mr. Young for status on October 27th. So let's set that for a final status so that if we need him, let's bench warn him and get him back if y'all want to continue your prosecution on him. Otherwise, it continues to ride the docket and OCA's gonna ding me for letting him ride the docket. So 10/27. All right, court calls CR 25-239, State of Texas versus Matthew Scott Williams. Mr. Williams was set for arraignment. It's my understanding that Mr. Williams is still in the Fresh Start program. I think we set him inadvertently. I think the state had made an announcement at the last docket that the state was willing to wait to begin its prosecution until he was released from this program. So, Mr. Abraham, if we can try to find out if he's still. Oh, the end of the year. Hmm. All right, well, he was supposed to appear via Zoom today, so I'm gonna set it again for September 15th and let's let's have him appear via Zoom so we can find out what's going on. I don't want to, that's too long. End of the year is too long. Is that everybody? All right, I believe that concludes the court's morning docket for the criminal cases. Court will stand in recess. We will resume at 1:30 for the jail docket.